Hello, hello, hello. This is Attorney Mike Gravel coming to you from Chicago. As usual, it's early Saturday evening. I got a few calls to look at. I'm gonna start with this one in Texas, but they're all represented, so I'm leery because it's just gonna be a pile of reasonable stuff happening there. But there might be nuggets. So let's give it a try, shall we?
Mr. Adams, can you hear me?
Yes, Your Honor, just fine.
All right, that's some kind of issue over here. All right, this is State versus Josie Bothell. This is cause number CR 22-2.
So,
Go, Mr. Adams.
I guess this is Judge Chris
Your Honor, Mitch Adams on behalf of Ms. Bohannon for record purposes. Your Honor, I have the
I don't know if I've had them.
discovery
I've seen it
materials in this
before, but I don't
case.
know if I've
I was
had it on.
notified last week by the DA's office that the audio visual materials are available. I have not yet had the opportunity to pick those up. I will do so after our hearing today. In
Iris knows this
reviewing
judge.
the materials
She's
I
in
do
Texas,
have, I
right?
thought I
She knows
might
all the
have
judges.
there's a possibility there may be an evidentiary suppression issue here that I could argue. So I went ahead and filed a motion
Van
to suppress
Zandt
today,
County, Texas.
or earlier today. That probably hasn't
Wherever the hell that is.
to into your hands or to the state's hands yet.
Thank you.
I went ahead and did it out of an abundance of caution, just to have it ready in case what I see in the video doesn't dissuade me from proceeding with that. Ms. Bohannon is currently on deferred adjudication probation in Smith County. There is a motion to adjudicate on file in that case, and there is a blue warrant for her from Smith County. It's a no bond warrant. Smith County, of course, being Smith County, doesn't set bonds on those. At any rate, I guess that's a long-winded way of asking the court to set for another pretrial hearing, so I can get a copy of that video material, review it in conjunction with the printed material, and see how to proceed or whether to proceed on the suppression issue that may or may not exist.
Judge State would have no objection. I do believe that the clerk emailed me a copy of the motion to suppress just because it was set today. I have not had a chance to review it, but we do need to get Mr. Adams his discovery. I am aware it is ready, but we need Mr. Adams to have it and review it. But we would be unopposed.
All right, correct. You said Ms. Bothell for an additional pretrial hearing. Are you available on
That is cool.
December 15th, Mr. Adams?
Yes, Your Honor.
You as well, Nigel.
All right, court sets Ms. Bohannon for pretrial December 15th at 1:30
Pretrial.
if she's in custody. 9 a.m. if she's gone.
Yes, sir.
I probably will before it's over.
All right, Your Honor. That concludes my announcement in this case. I don't have anything else on your docket today, to my knowledge. May I be excused?
Yes, sir. I believe that's all.
Thank you. Nice to yeah.
I was looking for a high-speed chase.
I'm ready to.
Honestly, that sounds better. But who knows what craziness lurks in Van Zandt County?
Yeah.
So far, this judge looks all kinds of serious and stern.
I was just, all right, let's check.
Mr. Schmidt, who are you ready?
Michelle Lynn Daly.
The world would be a happier place. That's all anyone really
All
wants.
right, court called CR 14460. I bet it's a write-in. And they added
What's the name?
Michelle Daly, D-A-I-L-A-Y, add on.
Yes.
Motion to go ahead, Mr. Schmidt.
What towns? Somebody tell me from Texas. What's Van Zandt County?
Motion to withdraw their NTA, and to
Thank you.
continue. Or actually, this is terminate community supervision. I need to make sure that Ms. Heisel is aware of that.
Did I circle the wrong one?
Well, it's motion to withdraw states, motion to revoke and terminate community supervision. I believe
There should be, right above, the order, there should be 3 options with 1 circled. If not, I will get that corrected and get it to the courthouse.
okay. And if I could, can you see
Yes, so I have continued circle there.
Screw White Claw. They haven't
Oh, I don't
sponsored
have
me yet.
glasses on. Okay.
I'm going
We
with
need to
Truly.
change the title of the document because it says terminate.
Fair enough.
But if we're going to continue and place her back on probation, Ms. Daly was arrested for the offense, which triggered the motion to revoke, and I believe the state's rejected that case. And we'd ask the court to approve that.
Okay, is there any amendments to our conditions of community supervision, or is just withdraw the motion and we're back?
Your Honor, I believe she already had some sanctions. However, at this time, we're not adding those to the conditions. The basis, the overwhelming weight of the state's MTA was that new offense, which has been rejected by our office for prosecution. So we think it's in the interest of justice to put her back on. I know she was a little bit behind, but I believe she still has 3 years remaining. The probation department indicated to me that they thought
High noon,
that she
sure.
had
I can
time
be
to
bought.
comply with the additional
Whoever
terms of
sponsors
her
me.
originally ordered community supervision.
Okay, grant the state's motion to withdraw, motion to revoke. Court will continue Ms. Daly on her
Don't I
previous
know it.
court-ordered community supervision.
Thank you.
I've been good today, though. I haven't had anything. I'm going to the Smoking Pulp show tomorrow, so that probably won't be the case. But tonight I'm being good.
They weren't good with females first.
Canton, Texas, east of Dallas. Okay. Thank you. Boy, is this Judge Stern. I mean, he seems like
Your Honor, are you ready
good.
on Ms. Morman?
but
Yes,
he
very
does
ready.
not even crack a
All right, Ms.
smile.
Morman, CR 16139, State versus Polly, Elise Morman.
Ooh, that sounds good, Gia. I'm coming over.
I'm sorry, Judge, what'd you say?
What's the announcement today?
Oh, we're ready to execute a plea.
Okay.
Well,
All right, what are the
Oh,
terms
yeah.
of the plea?
yes, Your Honor, it was a motion to revoke her probation. It was abandoned endangering a child by criminal negligence, state jail felony. She's being sentenced to 180 days in jail with 180 days
coffee.
credit. She served more than that, I believe. She's been in custody in Smith County and she was bench warranted from Plain State. So she also owes the remainder of her financials, which is $1,208.
This is what I'm talking about. Right there.
And she's going to plead true to all accounts in the motion to proceed.
This is a bond violation. I was too busy reading
I
your
think
chat.
that's it, Judge.
Okay, thanks.
No, that's the Smoking Pulps. That's all good. Need you around. Look it up.
Is the state
Good
proceeding
stuff.
on the motion to adjudicate file on October 1st, 2020, or has it been amended?
Thank you.
The one that we have, Judge, is October 1st, 2020.
Seriously.
And then honestly, we've been not at fault of Ms. Morman, but just kind of chasing her from Smith County. I think they denied a bench warrant once, if I recall.
No.
And then she got, shipped down to Plain State. So we've been trying to get
Here's
this done
diet soda.
for probably over a year. So it is, yes, Your Honor, to answer your question, it would be, it was the one that was filed on October 1st of 2020.
Ms. Morman, if you will, please, ma'am, raise your right hand. I place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you. You can lower your hand. Just make sure you speak up loudly and clearly for me. So one, that I can hear you, and two, so my court reporter who's present with me in the courtroom can take down what you have to say, okay?
Yes, Your Honor.
All right. Ms. Morman, let's see.
I might go
here.
to F and F.
Pull up your motion.
Haven't gotten an invite, but I haven't been there for a while, so you know.
Ms. Morman, it appears that you appeared before the court on March 12th of 2019.
All right,
You
Zarevo.
pled guilty to the offense of abandoning or endangering a child with criminal negligence, a state
Oh.
jail felony. Court heard the evidence on that date, found that there was enough evidence to convict you, but the court followed a plea agreement in your case.
Rough.
And the court deferred a finding of guilt and placed you on community supervision for a period of 3 years. The court also ordered you to pay a $1,500 fine. It was during your period of community supervision that the state has filed its motion to adjudicate and revoke on October 1st of 2020. In this motion, the state has alleged in 8 separate counts ways that they believe you have violated your community supervision. Have you had enough time to review this motion with your attorney, Mr. Weiner?
Yes, Your Honor.
You feel like you've had enough time to talk with him about this and have all of your legal questions answered?
Thank you, Maria, for that
Yes, Your
reference.
Is there anything about the paperwork that
That
you've read
nobody
over
will
and
get.
signed today
I
that
mean,
you do not
nobody.
understand?
No, Your Honor.
And where you have signed in the
But I did.
paperwork, you're telling me that that is your true and correct signature, and you only signed once you were confident you knew what you were signing.
Yes, Your Honor.
And Mr. Weiner, do you believe Ms. Morman to be competent to enter into this plea agreement today?
I do, Your Honor.
And you've explained to her her rights with regards to this motion,
I have, Judge.
and you believe she understands those rights?
Yes, Your Honor.
And is she going to be pleading true to all 8 counts? And does she waive the formal reading of the state's motion to adjudicate?
Yes, both questions, Judge, would waive formal reading.
All right, Ms. Morman, at this time, I'm going to ask you.
Otherwise known
and I'm having, for the
as an
record,
affidavit
I'm
of
having
truth.
this displayed to you via Zoom. How do you plead to counts 1, 2,
Thank you, Knight of Knee.
3, 4, 5,
Yes.
6,
In
7?
addition to the super
and 8?
chats and
Are
the
those counts true or not true?
moderating.
True.
Ms. Morman, are you
You're
telling me
good.
that those counts are true because in fact, what's alleged in those counts is in fact true? You're not just saying that to get a plea agreement?
Yes, Your Honor.
Oh, I'm fully
All right.
participating in
And
Pantsless
Ms.
Friday
Morman,
already.
has anyone threatened you, forced you, pressured you to make you feel like you had to plead true today?
No, Your Honor.
All right, the court will accept the defendant's pleas of true to each count as alleged. Mr. Weiner, any objection to the admission of the defendant's waiver of rights and plea of true?
No, Your Honor, we previously received, reviewed, and have no objection to the state's offer.
All right, then the state's evidence is admitted and the court takes judicial notice of Ms. Morman's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
Not regarding the plea, Judge.
Okay. All right, Ms. Morman, then based on the evidence presented to the court today, the court finds that you have violated the terms and conditions of your community supervision. Court will follow the plea agreement in your case. The court hereby adjudicates your guilt, convicts you of abandoning or endangering a child with criminal negligence, a state jail felony. The court will revoke your community supervision today and assess your punishment at 180 days confinement in the Van Zandt County Jail. Court will issue you credit
Jeez.
towards that sentence for 180 days. Court will order you to pay the balance of your financial obligations. When you are released from TDC, then it's important that you report to the Van Zandt County Courthouse and speak with a court compliance officer to make
thank you.
arrangements so that you can discharge what you owe the county in this case, so that a warrant is not subsequently issued for your arrest. Do you understand?
Yes, Your Honor.
All right. Ms. Morman, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. Good luck to you.
There is one just housekeeping matter, Judge, and I'm probably overkill here. But for some reason, I mean, there's been a hold from Van Zandt County for this charge on her before. But for some reason, there's an outstanding warrant for her for this particular charge. It's my understanding by executing this plea bargain, that warrant would be extinguished or withdrawn. I just don't want to do anything to trip her up. She's time served on this, but she still has, she's serving a state jail sentence out of Smith
Thank you,
County. She
Edney.
should be released on November 30th. So I just want to make the court aware that, when we started this plea, she had an active warrant for this charge. I just want to make sure there wasn't anything that we needed to do to alleviate that.
No, the court is aware that the court found her bail to be insufficient back in April of this year. And Deputy Everett has brought that to my attention, and it's going to be my, what I'm going to do is order that to be withdrawn based on her plea.
Thank you so much, Judge. All right, that's all I have. May I be excused?
Yes, sir.
Thank you.
Ah.
You're good.
She looks innocent, man. It's hard to believe she's doing what she's accused of, but she admitted to it.
December 1st.
All right, Mr. Schmidt, who are you ready on?
Austin Hensley.
Mr. Hensley, CR 22-274. Mr. Hensley is to enter a plea today, is that correct?
That's correct, Judge.
Can you tell me the terms of the plea, Mr. Schmidt?
Yes,
Interesting.
actually, the state's recommending that upon a plea of guilty, the court defer a finding of guilt, put Mr. Hensley on community supervision for a period of 6 years, assess $1,000 fine. In addition to that, he's to submit himself to safety as a condition. The state has also agreed to take into consideration a unfiled VA 2022-0792 under 1245 the Texas Penal Code. $290 in court costs, $515 in reimbursement fees.
Any restitution?
There is none listed on here, Judge.
No, Your Honor, there's no restitution requested.
All right, Mr. Hensley, raise your
All right.
right hand, sir. I'm going to place you under oath.
This
Sir,
is
do
too
you
dry.
swear that the testimony you give to the court today will be the
I've got a
truth, the whole
knock
truth,
stream.
and nothing but the truth, so help you God?
Yes, sir, I do.
And
All
I've
right,
got
lower your hand. All right, your name is Austin
on the
Keith
struggle
Hensley, is
bus
that right?
in Bethel.
Sir.
And Mr. Hensley, are
Washington,
you
I
a United
believe.
States citizen who does read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with a mental
No.
condition?
Yes, sir.
What have you been diagnosed with?
PTSD.
Are you currently under doctor's care or medication for PTSD?
No, sir.
Do you feel like you have a rational understanding of the proceedings that have gone on in this case, including today?
Yes, sir.
Now, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with him as your attorney?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case and have all of your legal questions?
Okay, we can't do that. I like that, but this is just too orderly. The judge has that room too under control. Let's watch this guy struggle with his bond conditions. This is a little more exciting.
I was going to say that numbers before the other one, but
Sorry.
hey, I rarely catch details like that. All right, 32797 on the VNCO, the new one, and then the other one is 32796.
Correct.
Is this
Got it.
Washington?
All right, and then okay, I got the
For my,
email, municourt@bothellaw.gov.
people here.
Okay, I'll get that right over, Your Honor. And we're ready to proceed.
All right. Do you want to go ahead and do the arraignment first then?
Sure.
All right.
Yeah.
What would you like to put on the record with regard to cause number 32797?
Your Honor, John Polito on behalf of Shangwan Zhuming. Actually, it's Zhuming's his first name, Shangwan is his last name. He's been charged with one count of violation of a no contact order. I haven't formally seen the complaint, but I know what it's going to say, and I do know the elements of that crime. I've gone over them with my client in the breakout room.
Mm-hmm.
I would waive any further formal reading of that charge and ask that the court enter a plea of not guilty once we confirm his identity.
All right.
Oh, and I've gone over the advice of rights form. I have it here. I'm going to be emailing that over forthwith. So I've gone over that in detail with him as well. Thank you.
All right. Thank you. Mr. Shengguan, good morning.
Good morning.
Is Shuming Shengguan your true name?
My first name, Shangwan's last name.
Okay. Say your name for me again, please.
If I
then.
could rewind.
Shangwan first name.
Okay. Mr. Polito indicated to me that he went over the charge with you, the violation of a protection order, which is a gross misdemeanor, maximum possible penalty of 364 days in jail, $5,000 fine, and 5 years of probation. He also went over your constitutional rights with you. Did you understand all that he went over with you?
Yes, ma'am.
All right. Mr. Polito, did you indicate a plea of not guilty at this time? Waiving formal reading is my memory.
Yes, sir, I did. Thank you.
All right. Not guilty plea will enter. The court has had an opportunity to review the police reports to make a finding of probable cause. What is the city's request with regard to release and conditions?
Your Honor, regarding actually both cases, to begin with, the defendant was arraigned on the assault case on 11/7. That was, in the city's opinion, a fairly egregious case. I wasn't here, but it looks like the city asked for $5,000 in bail, and he was released on his recognizance. He was released with a no contact order, as well as a condition to abstain from alcohol and non-prescribed drugs. And that was on the 7th. And here we are back on the 8th, or I'm sorry, on the 9th. It was less than, 2 days later, when the officer went to their home to give him a copy of I think it was the firearm surrender form. The defendant was found with his wife drinking alcoholic beverages in violation of the condition, and then obviously in violation of a no contact order. So, Your Honor, it's pretty clear that the defendant cannot abide by court orders. It doesn't have any intention of abiding by the court orders. He was in violation of conditions of the NCO as well as the abstain condition. Again, the underlying assault was, fairly egregious, and for that reason, the city is asking to revoke CR on the underlying assault case and to impose $20,000 bail today.
Mr. Polito.
This is good. I actually want to know.
Thank you, Your Honor.
Everyone's reaction.
So I'll address the two issues. One is I'll take what I think is the easy one first, which is the abstain condition. The officer that came upon the home was looking through a window and observed what he thought was my client consuming alcoholic beverages without breaching too much attorney-client privilege. A bottle of kombucha, which is the color of dark brown, would look like a beer to somebody.
Okay, that's interesting already. This is one of the reasons I did it. I know this is minor, but it's kombucha. Kombucha is not something you drink to get drunk, but it has alcohol. Does that violate the conditions? I mean, you could drink like a quart of that stuff and not get a buzz, but it does have alcohol, and his condition is no alcohol. Tell me what you think in the chat.
Anybody, including an officer from outside, if the court looks at the PC certificate in this case, there is a significant amount of interaction between my client.
By the way, I'm not buying any of that BS. He was probably just drinking, and he's using this kombucha as a smokescreen. But nonetheless, it just still raises that issue.
And the police officers, not once does any of the police officers who actually engaged him face to face within a very close distance said that he'd been drinking, that he exhibited any signs of being drinking, of having consumed alcohol, whether that's red eyes, an odor of alcoholic beverages, or anything of that sort. So I don't believe, based on that limited information you have in front of you, that you have a reasonable that there's a reasonable inference that my client was consuming alcoholic beverages rather than the officer just believing the worst. Secondly, with respect to the no contact order, you have information before you. I see Ms. Liu is in on this hearing. So as she said in the police report, she said that she came over to the home. My client is residing there. She is residing at her parents' home in Edmonds. And I looked at the no contact order when she said she was moving out, and there was nothing in there that said he couldn't go to a specific residential address. So my client was there, and she said that she came over after she had left and wanted to cook for him. That's the evidence before this court on the violation. So I just want the court to understand what that frame.
This guy's just innocently kicking back at the house, having some kombucha, and she wants to come over and cook for him. You can sell it that way, and that might even be what happened. I'm not saying, but it's just like this characterization. The judge does not like it. Does not like it.
Framework look like. All that being said, the optics on this are not good for my client, and I understand that, at least now, before we dig deeper into the actual facts of what happened, how long she was there.
I'm just saying it's very, very mild by my Naughty Adventure standards. That's all I'm saying. The way he's characterizing this wouldn't even qualify as anything. Okay.
And whether he knew she was there for enough time period for it to be a knowing violation. I would request that the court impose the $5,000 in bail in this case. I see Ms. Liu again has gotten on here. She has to understand under no set of circumstances that this is an order that she has any control of whatsoever. She made statements in there that said that she was trying to get the order lifted. But as this court's well aware, I don't have to educate this court at all. This is not her order. This is your order, Your Honor. This is your order. And I'm prevented from saying too much more right now other than that, Your Honor. But Ms. Liu is here. She needs to understand in those certain terms that this is not her order. My client certainly knows that, and I'll deal with that issue later. But just to give you a little better frame of what's in front of you in writing, as opposed to my client brazenly going over to a place where she was not there. She had left the residence to reside somewhere else. Thank you, Your Honor.
Your Honor,
I'm leery of that too. It doesn't really matter, but that's what she's going to say. But I'm guessing that she was there and he just went over there. However, he went over there. If I'm just talking reality here. I don't think anything wild was going on, but I think she feels bad. She does want to spend time with him. She is living there. She's going to say she's living at her mom's, but she does live there. And she said, come on over. And they were having dinner and he was probably drinking, but yeah, you know, whatever. All that's fine, except for the fact that it violates his court order.
I apologize. The city neglected to mention the city was also requesting a scram condition today.
Well, let me address that. For the same reasons, Your Honor, there's absolutely no proof before this court substantially that my client was consuming any alcohol whatsoever. He was also intaked into the jail. I'm assuming they would have also noted any alcohol issues whatsoever. There is just nothing this court should find that is reasonably conclusive that my client was consuming alcohol. Nothing. Just an officer saying, I looked through a window. What was he drinking? What did he say? He said they were consuming alcohol. How can you tell that through a window from 30 feet away, wherever you are? So there's just no proof of it, Your Honor. So we would strongly object to the scram device. And since this is a case that doesn't involve my client brazenly going to the residence in violation of this order, given the circumstances and the evidence that you have before you in the PC certificate itself based on Ms. Yu, this isn't one where we need to track him and where he goes. He's going to be at his home. He's a victim. He was sitting at his own place chilling, and then she came in and violated him. That's the argument. Contractor. Most of his income, the family income, is from rental units that they own. So we don't need to track him. He was in a place where he had a right to be. Now, what happened and when his wife got there is a whole different issue. But so thank you. I'm glad I had the opportunity to address that.
So, Mr. Polito, you were not here at the arraignment on the assault fourth degree, and you're correct. You actually used the exact terminology that I told your client at that time when I issued the no contact order, that it is my order, not Ms. Liu's order. She has no ability to alter or change that order. The client actually had a number of questions, and I directed him to speak with counsel to get clarification.
He's making a good case for his client.
So at this particular point in time, I am not particularly impressed with the fact that your client was in violation of that order within 2 days of it having been issued. I'm also not terribly impressed that your client did not complete the requirement that I placed on him of providing this court with an affidavit of non-surrender with regard to any additional firearms.
Oh, no. Oh, sorry. I didn't mean to interrupt. Yes, we did. We did that. I filed it yesterday. Sorry, Your Honor. I didn't mean to jump right in, but I wanted at least. Did you email that over? I'm sorry.
I do see it now. I do see it.
Thank you, Your Honor. No, I jumped on that right away.
All right.
Once I was retained. And I've been dealing with somebody.
That actually helped him. She stole her thunder there. She's like, you definitely should have this affidavit over here. And the attorney's like, I did. I get it. It's close in proximity in time. It's not a big deal, but that takes her back a little bit. The judge is like, all right.
Records. Carrie, maybe? And we confirmed it, and then I emailed it over yesterday. Yeah, and that's why, ironically, that's why the police officer was there. But, the police officer, he was in a place where he had a right to be. So I'm not making any argument on that. So thank you. Anyway, just jumping on that. I just wanted to make sure that
I do see that
in contact with me.
But I'm still not impressed with the recidivism rate here and the idea that I understand your argument as to how long she'd been there, but if the officer walks up and sees people sitting at a table, I'm also concerned about the reaction to law enforcement being there. And the degree the officers had.
I don't know what she's talking about, the reaction. I literally don't know. If someone can explain it to me. I just watched this thing. This is my second time through. I'm concerned about the reaction to law enforcement being there. Did I miss something where, did he take off or something? I don't know. I don't see any weird reaction.
To go to make contact with your client. This is a situation, obviously, I think your client is actually, when I read the reports, I was surprised, but saw that they had brought a canine unit in, and understanding that firearms had been seized from your client previously, I can understand why the officers might wish to have a canine unit come in. I think your client was lucky not to make contact with that officer.
Good Lord, they got a canine. Why don't they bring the SWAT team here? It's a married couple. I don't know what he's done, but you know what? Before I say all this, I think she's probably cranked up because she's seen a lot more than I know about in prior situations.
So
I just want to see the canine.
I told you at the time, Mr. Shingwin, that we take our orders seriously. I explained to you the potential additional penalties that are associated with it, and I told you that it was my order. So at this time, I agree with the city that it is concerning to me that you will follow this court's orders. This appears to be a flagrant disregard, and I am concerned about some of the allegations, obviously, as I've indicated. I think that it is appropriate to set bail. I'm not going to listen to either party, though. I'm going to set bail at $10,000. I think that's the appropriate amount.
We sure do.
Should you post bail, you will need to notify the court in person or in writing of any change of address, have no new criminal law violations for which there is probable cause, make an appointment with your attorney, make it to that appointment. Silly to have hired Mr. Polito and not use him to the full extent of his abilities, and he can't help you if you're not talking to him. So make sure you make it to your appointments. Make it to your court dates, which I'm going to give you here in just a moment. Mr. Polito will be able to explain to you in greater detail what that means under the current court rules. Abide by the no contact order. Any protective order that is in place, you need to abide by it. Because as you have learned in probably a fairly unpleasant way, you're the one who goes to jail. I think I went over with you and explained, if she calls, you don't even answer. She knocks on the door, you don't answer.
Hey, thank you.
There's a lot of missed calls. There's a text message I don't answer.
Don't, please. Sean, please don't speak.
Please.
Thank you.
This
And yes,
is,
continue not to respond. Thank you.
do not respond, do not communicate.
And shut your
This
hole.
is my order, and as I've indicated to you previously, 2 convictions for this, and the third conviction after that, third violation after that, becomes an automatic felony. And Mr. Polito can explain to you, again, the courts take it very seriously. This is not considered a light matter. This is considered a very serious violation. So you need to start taking that approach to it as well. So,
Any simple assault that occurs while it's in place is a felony too.
and I went over that with him at the time of arraignment on the assault 4th degree when I issued the no contact order. It is a very serious situation. So I am not going to impose the scram device at this time because I agree that there does not appear to be sufficient evidence to support that. However, if the city does obtain that evidence, they will be free to raise that request again. All right? So with that, the assault case was scheduled for pretrial.
I think it's the 28th, Your Honor.
I think that's correct.
And can we have this new one track that? I mean, no, I don't want to join them for purposes of 4.1 or 4. I can't remember the court rule, but perhaps later we'll see that. But I would like, at least at this point in time, that they should track for judicial economy purposes.
All right.
Subject to any argument later if there's a trial and jointer.
All right. City have any objection to setting this matter with the assault 4th degree on November 28th for pretrial and the trial date of November 7th?
No, not at all, Your Honor.
All right. So we'll track this with the other matter. And those will be the court dates. And I think that still keeps us within time for trial.
All right. We'll do one from now.
I just want to make sure of that. When did I say? I said November 28th
I
and
think it was December 7th, Your Honor.
They're just scheduling there. Okay. Let me find it. There's only one guy who's good.
Now, that will be
That's the guy, but it's a 2-parter.
what's your name?
He's clearly
Hunter
very good.
McCoy.
Mr. Mr. McCoy, you've been charged with the manufacture, delivery, sale, or possession with intent to manufacture, deliver, or sell marijuana, or a Schedule 6 controlled substance, I should say. That would be a Class E felony if convicted. You've also been charged with evading arrest in a motor vehicle. That'd also be a Class E felony if convicted. And finally, you've been charged with possession of a firearm with intent to go armed during the commission of a dangerous felony. That would be a Class D felony if convicted. You understand what you're charged with?
Yes, sir.
Would you like me to appoint an attorney to represent you?
Yes, sir.
I'd ask you some questions on oath to make sure you qualify, as well as to set your bond, so you raise your right hand and be sworn in.
Even after you give him the tenancy discount?
This is the uniform affidavit of indigency that you filled out of jail. You swear or affirm that everything you filled out on this form and your testimony you give is true and accurate?
Yes, sir.
Thank you. You have a job?
Yes, sir.
Where do you work?
Colgan of Knoxville. It's a water filter repair specialist company.
How much do you make?
About 60,000 a year.
60,000 a year?
Yeah.
I mean, it makes a lot more in a side hustle.
Because I'm like an on-call, so it's like, it kind of depends on like extra commission and stuff like that.
Any property, a house or car that you own?
I rent an apartment. That's it. I don't really own any property.
Okay. You live in Knoxville?
Yeah.
How long you lived here?
I've lived in Maryville since I was like 6, and then I moved to Knoxville like last year, just because it's closer to my work.
I'm guessing that's close to Maryville and Knoxville. I don't know. I don't know the area. The judge seems to be familiar with it.
How long did you say you lived here?
About a year. In Knoxville. I've lived in Alcoa and Maryville since I was like 6. Actually, probably not even a year. I probably lived here. Actually, I was lived in Alcoa. I lived here like 4 months, but like I was living on Alcoa Highway, which is like really close to South Knoxville. But I mean, in like actual Knoxville, it's like been like 3-4 months.
Is that where you're from? Is Blount County?
Yeah, I mean, I was born in Alaska, but I've lived in Blount County since I was 6.
Okay. You have family here or there?
My dad lives in Alaska, my grandma lives in Oregon, but my mom's family, I don't really talk to them. They live down here, but I just don't really associate with them.
Okay. And is there anybody that would vouch for your liability to show up in court?
What's that mean?
Basically, that they would come and tell us that you're responsible and you're coming to court.
Oh, like you, like someone that I could have do that for me?
Correct.
Yeah. Like a supervisor or something like that?
Whoever you want. It's however you want to answer it. I'm not.
Yeah. I can get someone to do it.
Who would that be?
Austin Rhodes.
What I'm going to do on the 2E felonies, I'm going to set the bond at $1,000 each, so that's $2,000 total. And on the D felony, that's the firearm case, I'm going to set it at $3,000, so it'll be $5,000 total for your bond. The way that works is that's an appearance bond, so you would go through a bonding company, and you have to pay 10% of that, which is $500 plus this.
I have A1 bonding talking to my people right now.
So,
hopefully, like, I mean, they know I'm getting arraigned right now, I'm assuming, so.
Ties to community.
Okay, so plus about $37 to get out.
Okay.
I'm going to set this in court on Monday, October 31st, for a bond review. So if you don't post the bond, they can consider reducing it at that time. The judge can. If you do post it, they'll give you a different court date to go to when you're being released. Go to that one instead. And I believe that with you making $60,000, I don't think that you're indigent. You probably can afford an attorney. I would like to give you an opportunity to look.
I started working there like a year and a half ago, and I'm only 20 years old, so like I haven't been able to really like reach like, I mean, I've spent like almost like 50% of my first year's salary like on rent and like my car and everything. So like, I mean, I've just been, but I mean like it's the money, like I have enough money for an attorney. I was just want to see like what it'd be like with a public defender, and like I can fire a public defender and hire an attorney like pre-trial, right?
just wanted to see what he is not getting the concept. I just want to see what it would be like with the public defender. Like, we're not exploring options. We're not on a trip here. You either qualify because you're indigent or you don't qualify, in which case you have to get your own attorney. The court will appoint you an attorney if you can't afford one. We've just determined that you can. So this just isn't an exploratory experience here. He's not getting it. He's like, well, can I dabble with the public defender? And if it doesn't work out, hire one? No, you just got to hire one.
Well,
It's just not recommended.
well, I mean, I'm not going to recommend or not recommend anything.
Pete,
What it is
please
we can
portion
appoint one if
$2,000
you
off
can
him.
afford one. If you make $60,000 a year, you
Start
can
there.
probably afford one.
I just don't have one like in my phone right now. You know what I mean? So I just have to go find one first before like.
But if you are unable to secure an attorney, when you get to court, let the judge know. They can probably appoint one at that time.
Okay.
But for now, I'm going to find that you're non-indigent. And that's all I have for you.
Okay. All right. Thank you.
They'll give you a different court date when you're being released. I suspect you're going to post that bond.
Yeah.
Go to that
Wait,
one.
I get a
Don't worry
different
about the one that I gave you.
You said I get a different court date if I get released?
Yeah, you'll get a different court date if you're released. Don't worry about the one I told. Don't come here on Halloween if you get released.
He had Marley to post that bond on him, but they took it from him. I'm curious of whether or not he can use that.
Ask you some questions. That'd be a Class A merchandise at 700-4011.
That I was like,
Those weren't too fun. Let's get back here to when he comes back. Okay.
Try and get a hold of him prior to your court date, which if you don't post the bonds will be on Monday. And that's all I have for you.
hello, sir.
So I left some things out of your arraignment. Would you like me to read the allegations, what they're accusing you of doing?
Wait, sorry.
Would you like me to read the allegations, what they're accusing you of doing?
Yeah.
Let me finish filling out this paperwork. I also have to go over your rights. I don't think I did that. With it being a felony, we're required to. Felony charge.
I can't remember the charge. Probably $3,000.
I know they were really trying to press the agenda that I was like,
I've never done that.
Like,
So I don't
I already
know.
know they're accusing me of doing that.
Let me read it. It
That's
says
kinda
this
what I've
incident
never
occurred
charged
on
for.
or about Tuesday, October 25th, 2022 at 8:42 p.m. at J.C. Penney's on 7600 Kingston Pike. On that date, time, and location, I, Officer Fisher, observed a dark gray Jeep Grand Cherokee SRT parked near J.C. Penney's. The vehicle matched the exact description of a vehicle that had fled from narcotics just a few days prior to this incident. Upon making contact
What a quinky dink. Your vehicle looks just like a drug dealer's car.
with the vehicle, I observed the arrestee, Hunter McCoy, in the driver's seat, and Addison Beams, the victim, in the passenger seat. It says victim. There's no victim crime.
Okay.
But that's myself and other officers with the Retail Task Force activated emergency equipment, boxed Hunter's vehicle in, and instruct Hunter to exit the vehicle. It was at this time Hunter made the conscious decision to refuse officers' instructions and speed off. A short pursuit ensued through the parking lot before the subject vehicle lost control and struck a curb with the front right tire, rendering the vehicle inoperable. Hunter exited the vehicle and fled on foot, but was located in bushes by KPD officers a short distance from his vehicle. A search of Hunter's person revealed him to be in possession of 28.17 grams of marijuana in his pockets. Officer Kyle Bothell deployed his canine partner Dolly to perform an open-air sniff of Hunter's vehicle, which she positively alerted on. While searching the vehicle, officers located a large cache of U.S. currency, $4,615 in the center console, and 2 firearms in the back passenger floorboard. One firearm was a Glock 45 with an extended magazine, and the other was a Glock 19X. Both firearms had a round chambered. Due to the large amount of marijuana Hunter was in possession of, and the majority of the currency being in small denominations, I find it to be more probable than not for Hunter to be involved in the promotion and sale of illegal narcotics, leading me to seize the $4,615 in U.S. currency he was in possession of at the time. Hunter was placed into custody and transported to the detention facility. Detective Parton with the narcotics unit arrived on scene and took possession of the seized currency. The narcotics were placed in their narcotics locker and the firearms were turned into property. Hunter's vehicle was towed to Sutherland Towing Impound Lot. This occurred in Knox County, Tennessee.
Will I be able to get the towing information for when I get out so I can?
Yeah, I think so. You talk to an attorney about trying to get that information. Let me go over some rights real fast since this is a new felony charge. So you have something that we have to go over at this time. First is that you have the right to remain silent. No one can force you to make any statements. Any that you make voluntarily can be used against you. You have the right to an attorney. If you cannot afford one, I can appoint one, which I did not because I think that you can afford one. You have the right to a preliminary hearing as a probable cause hearing where the judge will hear the evidence against you and decide whether this case is strong enough to be bound over the grand jury for further prosecution. You understand those rights?
Yes, sir.
Now we're finished. I just had to normally I do that with the other stuff. I just forgot.
You're good. So there wasn't an extra charge involved with what you just said?
No.
It was more just so them wanting to be clear that they think I'm a drug dealer pretty much.
Well, I just wanted to make sure you.
Yes, they think you're a drug dealer. That's why they charged you with dealing drugs. I'm glad. I'm glad you. I'm glad you caught on. I'm glad you caught on to the situation. That's why they stopped you. That's why they looked at your car. That's why they made the allegations. That's why the dog sniff. That's why they caught you with a bunch of drugs and cash in your possession. Yes, those are the allegations they're making. Oh, good Lord.
You know what they're accusing you of doing.
You said what?
I don't have any stake in the case at all. I just want to make sure you're aware of what they're accusing you of.
They made that pretty clear to me, honest.
Yeah, you won't have to serve on that jury, Captain Colombo. That trial will settle.
Yeah, I appreciate it, though.
Okay.
I mean, show up, but it'll settle.
Can I come my boss down here? Unfortunately, that's happening.
All right, that's it. I don't want to step on Rob's stream over there. It's although I think I already have a little bit. I didn't mean to. Go over there and tell him hi from Law Talk with the Mike. Go tell Rob over on Friday Night Frenzy. I might stop in and say hi. It appears from the secret that I have an invite, so maybe I'll go over there. I'm being good, so I don't know. I've got some top secret Law Talk with Mike business to attend to. It's very, very intricate. So I'm gonna close this one down. Thanks for coming out. I tried in Van Zandt, Texas. Actually, kind of like that, but it was damn it, that judge was that Judge Martin. That's no way to get a playlist. Just be all stern and competent. And then have attorneys representing everybody, so all the business goes the way it should. I mean, it's good law, but it's horrible YouTube. Horrible. I don't know what they're thinking. Oh, they're thinking they want to conduct their law business in an appropriate way. All right, that's fair enough. All right, thank y'all for coming out. I will probably stop by Friday Night Frenzy. Either way, go over, tell Rob I said hi. All right, thanks.